Welcome to the Keeping Your Job Part B course. In this Keeping Your Job assessment, you will be introduced to the following: reasonable accommodations, scheduling, benefits, deductions in your paycheck, your right as a worker, dealing with stress and anxiety on the job, handling mistakes on the job, coping with change, responding to feedback, dating at work, and standard policies and procedures. American Disability Act. The Americans with Disability Act requires an employer with 15 or more employees to provide reasonable accommodations for individuals with disabilities, unless it would cause undue hardship. A reasonable accommodation is any change in the work environment or in the way a job is performed that enables a person with a disability to enjoy equal employment opportunities. There are three categories of a reasonable accommodation. 1. Changes to a job application process. 2. Changes to the work environment or to the way a job is usually done. 3. Changes that enable an employee with a disability to enjoy equal benefits and privileges of employment, such as access to training. Reasonable accommodations. Although many individuals with disabilities can apply for and perform jobs without any reasonable accommodations, workplace barriers may keep others from performing jobs which they could do with some form of accommodation. These barriers may be physical obstacles, such as inaccessible facilities or equipment, or they may be procedures or rules, such as rules concerning when work is performed, when breaks are taken, or how job tasks are performed. Reasonable accommodations remove workplace barriers for individuals with disabilities. Requesting reasonable accommodations. What must an employer do after receiving a request for reasonable accommodation? When the disability and/or the need for accommodation is not obvious, the employer may ask the individual for reasonable documentation about his or her disability and functional limitations. The employer and the individual with the disability should engage in an informal process to clarify what the individual needs and identify the appropriate reasonable accommodation. The employer may ask the individual questions that will enable them to make an informed decision about the request. This includes asking what type of reasonable accommodation is needed. There are also extensive public and private resources available to help employers and individuals with disabilities familiarize themselves with possible accommodations. How must an individual request a reasonable accommodation? The individual must let the employer know that she or he needs an adjustment or change at work for a reason related to a medical condition. An individual may use plain English and need not mention the ADA or use the phrase reasonable accommodation. Requests for reasonable accommodation do not need to be in writing, although an employer may choose to write a memorandum or letter confirming the request. Must an employer provide the reasonable accommodation that the individual requests? The employer may choose among various reasonable accommodations as long as the chosen accommodation is effective, i.e., it removes the workplace barrier. The employer may offer alternative suggestions for reasonable accommodations to remove the workplace barrier in question. If there are two possible reasonable accommodations and one costs more or is more difficult to provide, the employer may choose the one that is less expensive or easier to provide, as long as it is effective. How quickly must an employer respond to a request for a reasonable accommodation? An employer should respond promptly to a request for a reasonable accommodation. If the employer and the individual with the disability need to engage in an interactive process, this too should proceed as quickly as possible. Similarly, the employer should act promptly to provide the reasonable accommodation. In this section, we will go over types of reasonable accommodations. Please click below to learn more about reasonable accommodations. Is restructuring a job a reasonable accommodation? Yes. This includes 1. Shifting responsibilities to other employees for minor job tasks that an employee is unable to perform because of a disability. 2. Altering when and/or how a job task is performed. If an employee is unable to perform a minor job task because of a disability, an employer can require the employee to perform a different minor job function in its place. Can leave necessitated by an employee's disability be a form of a reasonable accommodation? Yes. Absent undue hardship, providing unpaid leave is a form of a reasonable accommodation. However, an employer does not have to provide more paid leave than it is provided to other employees. May an employer apply a no-fault leave policy under which employees are automatically terminated after they have been on leave for a certain period of time to an individual with a disability who needs additional leave? If an employee with a disability needs additional unpaid leave as a reasonable accommodation, the employer must provide the employee with the additional leave even if it has a no-fault policy. An employer, however, does not need to provide leave if, 1, it can provide an effective accommodation that allows the person to keep working, or 2, it can show that granting additional leave would cause an undue hardship. When an employee requests leave as a reasonable accommodation, may an employer provide an accommodation that requires him/her to remain on the job instead? Yes, if the employer's proposed reasonable accommodation would be effective and eliminate the need for leave. Accordingly, an employer may relocate minor job tasks or provide a temporary transfer instead of leave, as long as the employee can still address his or her medical needs. Is a modified or part-time schedule a reasonable accommodation? Yes. Absent undue hardship, a modified schedule may involve adjusting arrival or departure times, providing periodic breaks, altering when certain job tasks are performed, allowing an employee to use accrued paid leave, or providing additional unpaid leave. In this section, we will continue to answer questions about reasonable accommodations. Please follow along by clicking the options below. Is it a reasonable accommodation to modify a workplace policy because of an employee's disability? Yes. For example, granting an employee time off from work or an adjusted work schedule as a reasonable accommodation may involve modifying leave or attendance procedures or policies. However, reasonable accommodations only require that the employer modify the policy for an employee with a disability. The employer may continue to apply the policy to all other employees. Does an employer have to reassign a vacant position to an employee who can no longer perform his or her job because of a disability? Yes, unless the employer can show that it would be an undue hardship, the following criteria apply to reassignment. 1. An employee must be qualified for the new position. This means that A, he or she satisfies the skills, experience, education, and other job-related requirements of the position, and B, can perform the primary job task of the new position with or without reasonable accommodation. 2. The employer does not have to assist the employee to become qualified. 3. An employer does not have to bump other employees or create a position, nor does an employer have to promote the employee. 4. Reassignment should be to a position that is equal in pay and status to the position that the employee held, or to one that is as close as possible in terms of pay and status if an equivalent position is not vacant. Does a reasonable accommodation include changing a person's supervisor? No. The ADA may, however, require that supervisory methods, such as the method of communicating assignments, be altered as a form of a reasonable accommodation. Are there certain things that are not considered reasonable accommodations and are therefore not required? An employer does not have to eliminate a primary job responsibility. An employer is not required to lower production standards that are applied to all employees, though it may have to provide reasonable accommodations to enable an employee with a disability to meet them. An employer does not have to provide personal use items, such as prosthetics limbs, a wheelchair, eyeglasses, hearing aids, or similar devices. An employer never has to excuse a violation of uniformly applied conduct rule that is job-related and consistent with business necessities. This means, for example, that an employer never has to tolerate or excuse violence, threats of violence, stealing, or destruction of property. An employer may discipline an employee with a disability for engaging in such misconduct if it would impose the same discipline on an employee without a disability. Other reasonable accommodation issues. May an employer tell other employees that someone is receiving a reasonable accommodation? No, because this usually amounts to a disclosure that the individual has a disability. The ADA specifically prohibits the disclosure of medical information except in certain limited situations, which do not include disclosure to coworkers. An employer may certainly respond to a question from an employee about why a coworker is receiving what is perceived as different or special treatment by emphasizing its policy of assisting any employee who encounters difficulties in the workplace. The employer also may find it helpful to point out that many of the workplace issues encountered by employees are personal, and that in these circumstances it is the employer's policy to respect employee privacy. An employer may be able to make this point effectively by reassuring the employee asking the question that his or her privacy would be respected if he or she found it necessary to ask the employer for some kind of workplace change for personal reasons. Employers might also find it helpful to provide all employees with information about various laws that require employers to meet certain employee needs. Employers and employees can refer to the ADA and the Family and Medical Leave Act for more information. Other reasonable accommodation issues. May an employer ask whether a reasonable accommodation is needed when an employee with a disability has not asked for one? If an employer knows that an employee has a disability, they may ask whether he or she needs a reasonable accommodation when the employer reasonably believes that an accommodation may be necessary. An employer also may ask an employee with a disability who is having performance or conduct problems if he or she needs a reasonable accommodation. In this next section, we will go over limits on providing reasonable accommodations. This module will include undue hardships, evaluation principles, the cost factor, and fears and prejudices. Undue hardship. An employer never has to provide any reasonable accommodation that causes undue hardship, meaning significant difficulty or expenses. Undue hardship refers not only to financial difficulty, but to reasonable accommodations that are unduly extensive or disruptive, or those that would fundamentally alter the nature or operation of the business. Evaluation principles. Every request for a reasonable accommodation should be evaluated separately to determine if it would impose an undue hardship, taking into account the nature and cost of the accommodation needed, the overall financial resources of the business, the number of persons employed by the business, and the effect on expenses and resources of the business, as well as the impact of the accommodation on the business. The cost factor. If cost is an issue, an employer should determine whether funding is available from an outside source, such as state or rehabilitation agency, to pay for all or part of the accommodation. In addition, the employer should determine whether it is eligible for a certain tax credit or deduction to offset the cost of the accommodation. Also, to the extent that a portion of the cost of an accommodation causes undue hardship, the employer should ask the individual with the disability if he or she will pay the difference. Fears and prejudices. An employer cannot claim undue hardship based on employees' fears and prejudices, or because providing a reasonable accommodation might have a negative impact on employee morale. Employers, however, may claim undue hardship where reasonable accommodation would be unduly disruptive to other employees' ability to work. Please click on the boxes provided for you on the left to learn more information about limits on providing reasonable accommodations. Modification of hours. Must an employer modify the work hours of an employee with a disability if doing so would prevent other employees from performing their jobs? No. If modifying one employee's work hours or granting leave would prevent other employees from doing their jobs, then the significant disruption to the operation of the employer constitutes an undue hardship. Fixed date of return. Can an employer deny a request for leave when an employee cannot provide a fixed date of return? In some situations, an employee may be able to provide only an approximate date of return because treatment and recuperation do not always permit exact timetables. If an employer is able to show that the lack of fixed return date imposes an undue hardship, then it can deny the leave. Undue hardship could result if the employer can neither plan for the employee's return nor permanently fill the position. In other situations, an employer may be able to be flexible.
Joe, I just got a new job and I'm having difficulties.
What kind of difficulties are you having, Sue?
Well, I haven't told my boss yet, but due to my disability, I'm having a hard time remembering everything. What should I do?
Well, if this is preventing you from performing your job effectively, you may want to consider disclosing this condition to your boss.
I'm afraid to do that because he might fire me.
As long as you can perform the essential functions of the job but require a reasonable accommodation to do so, then generally it is not an issue. An employer cannot terminate someone because of their disability, but can terminate someone if they cannot perform the job accurately or if the accommodation requires undue hardship.
So, you're saying it may be a simple fix? What is a reasonable accommodation?
A reasonable accommodation removes workforce barriers so a person can accurately perform their job. There are three categories of reasonable accommodations: changes to a job application process, changes to a work environment or the way a job is usually done, and changes to enable an employee with a disability to enjoy equal benefits and privileges of employment, such as access to training.
How did this come about?
It is part of the Americans with Disabilities Act, which requires an employer with 15 or more employees to provide reasonable accommodations for individuals with disabilities unless it causes undue hardship. In your case, a reasonable accommodation may be as simple as a request for lists of tasks that need to be completed during each shift. In each case, a reasonable accommodation may be physically altering equipment so it is easily accessible or altering electronics for the visual or hearing impaired. This is evaluated on a case-by-case basis, which is why it is very important to disclose with your supervisor as soon as you feel like it has an impact on your performance.
I am nervous about this. How do I disclose my disability to my supervisor and request a reasonable accommodation?
You must let the employer know that you need an adjustment or a change at work for a reason related to a medical condition.
Well, I don't know enough about American Disability Act to speak of it.
There is no need. You can use plain English, and it does not need to be a formal request or written form, but an employer may want to have something in writing confirming your request.
So that's it? What happens after the request is made?
When a disability is not obvious, like in your case, an employer may request documentation from a doctor about your disability and limitations. At this point, you and your employer will then begin to talk about individual needs. The employer may ask questions to better understand what they need to do to accommodate your needs. Just remember, this is to help both you and the employer to try to be comfortable when discussing this. You can also ask your job coach to assist you in this process.
Once I disclose my disability and need for an accommodation, does the employer have to comply?
The employer may agree with the reasonable accommodation suggested as long as the chosen accommodation is effective, or the employer may offer an alternative suggestion. Also, the term reasonable is subjective and may cause undue hardship on the employer. In this case, they may also offer a less expensive accommodation to suit both needs.
Once my employer and I decide on an accommodation, how soon should they respond?
Generally speaking, this should proceed as quickly as possible. There are no specific time limits, and it can vary according to each circumstance.
Is restructuring my job a reasonable accommodation?
Yes, this may include sharing tasks you may not be able to do with another employee that is capable of performing it. It may also include altering when and how your tasks are performed. Your employer may replace a task you cannot do with a simpler task that you can complete.
What if I need a leave of absence? Is this considered a reasonable accommodation?
Yes. However, an employer does not have to provide any more paid leave than they would any other employee, as long as it does not provide undue hardship to the company.
What if I need additional unpaid leave?
If an employee needs additional unpaid leave as a reasonable accommodation, the employer must provide additional unpaid leave unless the employer can provide an effective accommodation that allows the employee to continue working, or if the leave of absence causes undue hardship on the employer.
What if I need to change my schedule?
An employer can provide a modified work schedule if it is needed. This includes taking breaks more frequently, shortening shifts, and altering tasks.
What if I can no longer do my job? Does my boss have to reassign me to another job within the company?
Yes, your employer has to reassign you to another job if you can no longer perform your original job responsibilities, but only if you qualify for the new position. Other employers are not being shifted around, and the new position needs to be equal in pay and status.
Does a reasonable accommodation include changing my supervisor if I want a new one?
No. The ADA, however, may require that the method of supervision be altered, such as communicating assignments.
You mentioned that a reasonable accommodation needs to be discussed, and an agreement should be made between the employee and employer. Are there certain things that are not considered a reasonable accommodation?
Yes. An employer does not have to eliminate your primary job responsibility. For example, if your primary responsibility is cashier, then the employer does not have to eliminate cashier responsibilities. They also do not have to provide personal use items such as hearing aids, eyeglasses, prosthetic limbs, etc. In addition, your employer never has to excuse a violation of a policy such as violence, stealing, and destruction of property.
I am still nervous about telling my boss. Now everybody in the company will know something's wrong with me.
Don't worry, Sue. Your employer cannot disclose any information about your medical condition or that you receive a reasonable accommodation. If asked, your employer can only state that it is policy to assist people that may be having difficulties on the job.
Can my boss ask me if I need a reasonable accommodation if it's obvious I'm struggling?
An employer can ask if it is needed upon hire if you disclose that you have a disability, or if you have disclosed that you have a disability and are showing difficulties after you have been on the job for a while.
You've mentioned undue hardship a few times. What does this mean?
Undue hardship means significant difficulty or expense. Undue hardship refers not only to financial difficulty, but to reasonable accommodations that are unduly extensive or disruptive, or those that would fundamentally alter the nature or operation of the business. This is evaluated very carefully for each case. Usually, an employer will exhaust all efforts before concluding that it will cause undue hardship.
I feel a little better about talking to my boss now. Do you mind helping me if I get nervous or if there's any confusion?
Certainly. This is something that employment consultants assist with to assure success on the job.
Scheduling, benefits, deductions, and your paycheck. Dependability, showing up, and being on time is the bottom line for most Florida employers. They have to be able to cover all shifts. They have to depend on employees to remember their schedules and to call in as soon as possible if they can't make it. They simply can't afford to keep people who don't show up or who are often late. During your first week on the job, you will probably also be informed of your job-related benefits. These are often called your fringe benefits. Fringe benefits include things such as your health insurance, life insurance, paid time off, and retirement plans. Some of these benefits are paid by the employer. The cost of others is shared by you and the employer. In this case, your part will be deducted from your paycheck. Some payroll deductions are required. Other deductions may be voluntary. The kinds of fringe benefits you get can vary from a lot to none at all. Some larger organizations, such as hotels, offer full-time workers many benefits. Their fringe benefits can make a big difference in the real money value of your job. If you work for a smaller organization with fewer employees, you may get fewer benefits. If you work part-time, you may or may not get any benefits. Tax deductions. Most people can expect to have 15%, 15 cents out of every dollar or more of their paycheck withheld for taxes and other deductions. Here are the most common required and voluntary deductions and benefits. Federal income tax. Most workers must have money regularly taken out of their paycheck for federal taxes. In January, your employer will give you a form called a W-2 form. It will show your salary for the year and all the federal taxes that you have paid. You will need to include this form when you send in your income tax for the year. Taxes are due April 15th for the previous year. Federal Insurance Contribution Act. While you are working, the government withholds part of your paycheck and places the money in a Social Security fund in your name. An employer must match your contribution to the Social Security fund. This fund will pay you a pension when you reach retirement age. When you die, your spouse can continue to collect benefits. The funds will also pay benefits to your children who are under age 21 if you die. In addition, the funds pay you and your dependent if you are disabled for more than 12 months. Today, you can collect the full benefits of Social Security when you turn 66. By 2027, it will increase to 67. Most experts today say that Social Security will not be enough in the future to cover your expenses when you retire. It should only be a part of your retirement plan. Workers' compensation insurance. Most states, including Florida, require employers to carry this insurance. It pays for injuries that occur on the job. It also pays for part of the payment for time off the job if you are injured in a work-related accident or illness. Unemployment insurance. In most businesses, employers must contribute to an unemployment insurance fund run by the state of Florida, or they must agree to pay your unemployment claims. If you are laid off from your job, you may file a claim with your state employment agency. Weekly benefits are paid for up to 26 weeks or until you find a new job. You are usually required to actively look for a job while you are collecting unemployment. Health insurance. For many workers, health insurance is the most important of all job benefits. With healthcare so expensive, an uninsured injury or illness can cost a family thousands of dollars. Without the protection of health insurance, the life savings of a family can be spent very quickly. A family can face many years of debt. Many workers choose a job because of the health benefits it offers them and their families. Group health insurance plans through your company are usually much less expensive than individual plans. In addition, your employer will usually pay part of your health insurance cost. Individual plan. Employers will usually offer an individual plan. This covers only the person who is working, but many employers will also allow you to sign up or enroll your spouse. The word spouse is used in many forms and documents. It means your legal partner, your husband or your wife. If you have children or older parents as your dependents, you may be able to enroll in a family plan. Before you sign up for a plan, it is important to find out what your plan will and will not cover. Medical insurance helps pay for your doctor bills and many medical tests. Hospitalization. Hospitalization covers your costs if you have to stay in a hospital. Major medical insurance helps pay for your very large health bills, for surgery, and for expensive tests. Many health plans will also help cover the cost of prescription drugs. Choice of plan. Within your group plan, you may have other choices. For example, you may choose to participate in a plan where you choose your own doctor. This is usually the most expensive kind of plan, but you have the most choice. In this plan, you may have a deductible. This is the amount of medical costs you must pay out of pocket before the insurance company will pay your medical bills. The plan may also have a copayment. For example, you may have to pay $10 for each visit to your family doctor. You may instead choose to be a part of a health maintenance organization. A health maintenance organization, or HMO, is available to keep your costs low by managing health costs. But you must use HMO doctors and go to the hospital your HMO uses. You may not have a copayment for your doctor visits, but if you see a doctor who is not part of your HMO, you will have to pay for the whole visit yourself. County's Department of Public Health. If you do not have health insurance. If your new job doesn't offer health insurance, you may be able to buy an individual health insurance plan directly from a health insurance provider. These individual plans, however, are often very expensive. If you qualify, you may be able to get on a health care plan for low-income individuals through your county's Department of Public Health. In this exercise, we will discuss other possible deductions: disability insurance, life insurance, and other voluntary deductions. Please click on the boxes provided on your left-hand side to learn more. Disability insurance. Disability insurance helps you pay your living expenses if you are sick or hurt and cannot work for a long period of time. Disability insurance is an extra expense that may increase the deductions from your paycheck. Many people who are in good health do not take out disability insurance. Your company may or may not offer this benefit. You may want to talk with your personnel office about whether it is right for you. Life insurance. Life insurance pays the person you name in the policy in case you die. This person is called the beneficiary. Some employers may offer you some life insurance as part of your benefit package. They may also allow you to buy additional life insurance at a lower group rate. Not everyone has life insurance. Experts advise people who have young children or others who depend on their income to get life insurance if they can afford it. Other voluntary deductions. Other voluntary deductions your employer may offer to allow you to make other deductions from your paycheck. You may be able to automatically deduct your child support payments from your paycheck. You may be able to make regular donations to charities like the United Way. If you are a part of a union, You often can deduct the dues directly from your paycheck. Time off benefits. Your employer may also offer paid time off. Here are some of the most common paid time off benefits: holiday pay, paid sick leave, vacation leave, jury duty leave, and funeral leave. Please click on the boxes to learn more about time off benefits. Holiday pay. Many organizations pay you for major holidays. If you have to work on a holiday, they may pay you overtime. Paid sick leave. Employers who pay sick leave usually set a number of paid days you can use if you are sick. Often the amount is 1 to 2 days per month. If you miss more days due to illness, you may not be paid for those days. Most employers allow you to save up your days. Employers vary in their willingness to give you time off to take care of family members. Vacation leave. Some employers offer vacation leave. Often you have to work for a company for at least a year before getting paid vacation time. The amount you get may increase on the numbers of years you have worked for the organization. Jury duty leave. Many employers will pay employees for the time they serve on a jury. Be sure to let your employer know if you have been called up for jury duty. Funeral leave. When a member of your immediate family dies, you should be able to get medical leave. Companies may vary in how they define immediate family. Military leave. Members of the Reserve or National Guard are required to attend active duty training for at least 2 weeks a year. Employers are not required to pay for the time you are on active duty, but many will pay all or part of your salary for that time. Maternity, paternity, and adoption leave. If you work for a company that has 50 or more employees, the Family and Medical Leave Act says your employer must allow you at least 12 weeks leave. They do not have to pay your salary, but they do have to make sure your job is waiting for you when you come back to work. Paycheck. For many people, the day they get their first paycheck at a new job is a time for celebration. But remember, new employees do not always get a paycheck on the first payday after they start work. It may take longer for the paperwork to go through. Many offices will give you a schedule of the dates you receive your pay. Most people get paid once a week, once every 2 weeks, or once a month. Your paycheck usually includes 2 parts. The first part is the actual check you take to the bank or cash. The check is usually your net pay or take-home pay. When you get your first paycheck, be sure to check it over and make sure you understand each item that has been deducted. Take your paycheck to your supervisor or payroll right away if there is any problems, so they can get it straightened out. Please click on the folder tabs above to learn more about the aspects of a paycheck. Gross income. Your gross income is the total pay before anything is taken out. It includes any overtime you have earned. You may be paid either as a waged employee or a salary employee. If you are a wage employee, you are paid wages by the hours for the work you do. If you work more than 40 hours a week, you often can get paid time and a half for overtime. If you are a salary employee, you work for an agreed-upon salary. If you have to put in extra time to get the job done, you do not get paid overtime. Net income. Your net income, or net pay, is the amount you are paid after deductions. This is your take-home pay. Income to date. Most paycheck stubs will add up how much you have made so far during the calendar year. Pay rate. Your pay rate includes the amount you are paid. It is usually listed by the hours you have worked. Deductions. All the additional money taken out of your paycheck will be listed as deductions. These include the benefits and deductions described in Teamwork 2, such as federal tax, FICA, health insurance, retirement, and other deductions. Pay period. The pay period usually lists the beginning and ending dates of the period for which you are being paid. You should check this carefully to make sure you are being paid for all the time you have worked. Joan, I just landed a new job and I'm excited, but I attended orientation today and I am so confused on everything they talked about. There's scheduling, benefits, deductions, and my paycheck. There's just so much, and I don't want to do anything wrong. Can you help me to understand this stuff?
Sure. Let's start with scheduling. Scheduling is very important because an employer needs a dependable employee that will be able to cover any shift, keep track of constant schedule changes, show up on time, and not request too many days off. They simply cannot afford to keep people who don't show up or are often late.
How many hours do you work each week?
About 25.
That may explain it. Most employers offer benefits to full-time employees only. These work-related benefits are called fringe benefits. They include things such as health insurance, life insurance, paid time off, and retirement plans.
What about deductions? How much does the government take out of my check?
Not counting deductions for benefits, most people can expect about 23% of their total paycheck to go to taxes. This includes federal income tax, Social Security, and Medicare. Do I still have to pay taxes even if it's taken out of my paycheck?
Maybe. In January, your employer will give you a form called a W-2. This form shows your total salary for the year and the taxes you paid. You need to include this form when you send in your taxes, which are due by April 15th for the previous year.
I pay Social Security. So when can I collect Social Security?
Social Security payments begin when you reach retirement age or become disabled. When you die, your spouse can continue to collect benefits. After your death, your children under 21 can also collect benefits. If you become disabled for 12 or more months, Social Security pays you and all your dependents. Most experts agree that in the future, Social Security income will not be enough to cover all of your living expenses, so it should only be a part of a comprehensive retirement plan.
I get it, but going back to benefits, if I get full-time hours, why do I need health insurance?
For many workers, health insurance is the most important benefit. Because healthcare is so expensive, an uninsured injury or illness can cost a family thousands of dollars or more. You can get private insurance, but group plans provided by your employer are usually much cheaper. In addition, your employer usually pays part of your health insurance cost.
What's the difference between the plans offered and what do they pay?
Generally, there are 3 types of plans which affect who is covered. Individual plans only cover the employee. Many employers allow you to enroll your spouse in the plan at an additional cost. Family plans cover you, your spouse, and all your dependents. Medical insurance usually covers some or all the cost of doctor visits, medical tests, and prescription drugs. Major medical covers things like hospitalization and surgery.
What's the difference between HRA and HMO?
HRA, or choice plans, as they are sometimes called, usually let you pick which doctor you want to go to, but they are more expensive. HMO, or health maintenance organizations, are plans that are usually cheaper, but you have to go to the doctor and hospital that your HMO chooses. If you see a doctor outside of the HMO's network, you usually have to pay for the whole visit yourself.
What can I do if I don't have or can't get health insurance?
You can try to find a private insurer, but these plans are typically very expensive, if you even qualify. If your income is relatively low, you may qualify for special county or state programs for individuals without coverage. Ask your county or state government office for more information.
Are there other types of insurance?
Disability insurance helps pay your living expenses if you are sick or hurt and can't work for a long time. Life insurance pays to a beneficiary you designate in advance a substantial sum if you die. Most experts advise those with children or other people who depend on their income to get life insurance if they can afford it.
You mentioned that Social Security might not cover my living expenses in the future. What can I do? Are there any deductions to my paycheck?
Some employers allow you to deduct charitable donations, union dues, child support, and other payments directly from your check every month. Ask your personnel office for more information.
What other benefits are there?
Most employers offer some form of paid leave under a variety of circumstances, such as holiday pay. You are usually paid for major holidays, and if you have to work, you are usually paid overtime. Employers who pay sick leave usually set a number of days per month you can use if you are sick, and most employers allow you to save up your sick days. In addition, most employers offer vacation days if you have worked for the company for a certain time, typically a year.
Are there other types of leave?
Many employers offer paid leave for jury duty or the death of an immediate family member. Unpaid leave is typically granted for military service and maternity, but some companies do pay for this type of leave.
I think I understand, but how do I make sense of all the stuff on my paycheck?
Your paycheck usually includes two parts. The first part is the actual check you take to the bank. The other part contains the information about your income, deductions, accumulated leave, and so forth. The check or amount deposited into your account is considered your net pay.
What's gross income?
Gross income is the total amount paid to you before any deductions are applied. Make sure you understand each deduction listed and why it's there. If you don't, ask your supervisor or payroll department.
What if I'm not sure my paycheck is accurate?
In addition to deductions, most pay stubs show total income to date, pay rate, pay period, and, if applicable, total hours worked. You can double-check your pay by multiplying the pay rate by the total hours worked in the pay period. This should equal your gross income. Subtract each deduction, and this is your net income, the amount you take to the bank.
How can I make sure I'm paid for the hours I work?
Always keep track of your schedule, the hours you work, and when you take your breaks. If the hours you're paid for don't match the hours you work, speak to your supervisor.
In this activity, we will go over your rights as a worker, including employment at will, what is an employee, trade secrets, non-compete agreements, and compensation. Employment at will. Under Florida law, employment contracts which do not specify a definite term of employment are terminable at will. In other words, an employee can quit or be fired at any time for any reason other than those prescribed by law. For example, race, sex, handicap, age, etc. Recently, some have challenged Florida's at will policy, arguing that the employer's personnel handbook laid out a termination procedure requiring good reason or cause. The courts, however, have largely resisted these arguments and continue to view most employment contracts without a definite term of employment as terminable by either party or their discretion. Employment contracts which specify a definite term of employment are not terminable at will. Instead, both parties must abide by the terms of the agreement, otherwise they may be subject to a breach of contract lawsuit. What is an employee? Whether a worker is an employee or an independent contractor is an important question affecting the legal relationship between worker and employer. Employees are protected by state and federal wage and hour regulations, are entitled to workers' compensation, unemployment compensation, and are considered agents of the employer for purposes of liability. Independent contractors, on the other hand, are singular entities, not covered by state and federal employment law, nor are employers liable for their actions. The extent of relationship between employer and independent contractor is the terms of their contract. Trade secrets and non-compete agreements. Companies seeking to defend their competitive position in the marketplace will sometimes sue to prevent a former employee from divulging company trade secrets or may ask a worker to sign a non-compete agreement. A trade secret is any confidential information, machine, pattern, or process which may give its users an advantage over his or her business competitor. Trade secrets are the property of the employer, and no one, including an ex-employee, is permitted to share or disclose a trade secret without authorization from the employer. Employers can seek an injunction to prevent the sharing or use of a trade secret or sue for money damages if the trade secret has already been disclosed. The amount of money damages may be considered depending on the value of the trade secret. Non-compete agreement. Under Florida law, a non-compete agreement limits an employee's or independent contractor's right to compete with an employer in a given geographic area for a certain period of time. Usually, employers will seek such agreements from highly valuable workers with specialized knowledge or unique abilities. Whatever limits the employer imposes must be reasonable and go only so far as necessary to protect the employer from irreparable harm. For example, an employee may sign a non-compete agreement stating that should the employee leave, he or she must wait at least 2 years before working for the employer's arch competitor across town. Such a limitation would probably be reasonable since after 2 years, whatever information or expertise the employee has would likely be too outdated to cause the employer irreparable harm. Compensation. Compensation for work performed can be paid in a variety of ways. Wages in the forms of dollars per hour are the most common means of paying compensation. Florida law does not set a minimum wage. There are also salaries based on an annual rate, bonuses, tips, profit sharing plans, stock options, and commissions. Florida law requires that an employer pay overtime after 10 hours of work in one day. The Federal Fair Labor Standards Act limits the standard work week to 40 hours for most employees, excluding executives and professionals. Work beyond 40 hours per week requires overtime pay, which is defined as at least 1.5 times the regular hourly rate. Your rights as a worker. Click on a note to learn more. Discrimination based on handicap. The Federal Americans with Disabilities Act, ADA, and Florida's Civil Rights Act ban employment discrimination based on disability or handicap. Florida courts have defined a handicap or disability as a physical or mental impairment of a permanent nature that substantially limits one or more of the person's major life activities. By life activities, the law is referring to tasks that the average person can perform with little or no difficulty, such as caring for oneself, walking, sleeping, speaking, seeing, hearing, understanding basic concepts, and breathing. Sexual harassment. Sexual harassment is also a form of sex discrimination. Sexual harassment is defined generally as any form of unwelcome sexual conduct, either verbal or physical, which creates an intimidating, hostile, or offensive working environment. Examples of prohibited conduct include demands for sexual favors in exchange for employment benefits, unwanted sexual propositions or flirtations, sexually graphic materials on display in the workplace, leering, whistling, or gestures of a sexual nature, graphic commentary about an individual's body, sexual prowess, or abilities, physical contact of a sexual nature, such as pinching, grabbing, or unnecessarily brushing against another person's body. Employers should devise a sexual harassment policy if they do not have one already. The policy should state clearly that sexual harassment is illegal and will not be tolerated. The policy should be posted or otherwise communicated to employees, and procedures should be developed in the event an employee reports a harassment incident. Sex discrimination and sexual harassment. Title VII of the U.S. Civil Rights Act of 1964 prohibits employers from discriminating on the basis of sex, as does the Florida Civil Rights Act. One situation in which a worker may be subject to sex discrimination is in the matter of pregnancy. Employers who fire or refuse to hire a woman because she is pregnant, force her to take maternity leave, force her to take another job, or bar her from returning to work for a period of time against her pregnancy may be unlawfully discriminating against her. A pregnant woman's employment status can be changed only if her pregnancy interferes with her ability to perform her job. Discrimination based on handicap. Federal and state law does not impede an employer's freedom to hire or promote employees with the skills necessary to perform a position's essential duties. But the law does prohibit employers from making employment decisions based upon an employer's physical or mental abilities, not essential to performing the requisite work. Moreover, the ADA requires that employers make reasonable accommodations for physically or mentally disabled employees. A reasonable accommodation is not one which unduly burdens the employer, but it enables the employee to perform his or her job. Some examples include modifying stairways, doorways, drinking fountains, machinery, rearranging work schedules, and providing special training. Age Discrimination Employment Act, ADEA. The Age Discrimination Employment Act of 1967 is a federal law prohibiting age-based discrimination in employment. The ADEA covers both public and private employers, employment agencies, and labor organizations, and affects employees of applicants over 40 years of age. Among other things, the ADEA prevents most employers from enforcing mandatory retirement policies, except in special circumstances where age is a particularly important qualification. For example, firefighter, police officer, or airline pilot. As long as a person can satisfactorily perform the work required, he or she cannot be forced to retire. The Florida Civil Rights Act, passed in 1992, also forbids discrimination on the basis of age. Please click on the tabs provided for you above to learn more about your rights as a worker. Discrimination based on HIV or AIDS. Individuals with acquired immune deficiency syndrome or human immunodeficiency virus are protected against employment discrimination under both state and federal law. For example, Florida law prohibits any person from requiring an individual to take an HIV test as a condition of hiring, promotion, or continued employment, unless the absence of HIV is a bona fide occupational qualification for the job in question. Refusing or failing to hire, discharging, segregating, classifying, or otherwise depriving an employee of an employment opportunity because he or she may have HIV or AIDS. Refusing or failing, discharging, segregating, classifying, or otherwise depriving an employee of employment opportunities because he or she is a licensed care professional or health care worker who treats or cares for HIV-infected persons. Anyone found in violation of Florida law may be required to pay the aggravated party $5,000 in liquidated damages or actual damages, whichever is greater, in addition to attorney's fees and whatever other relief the court deems appropriate. Drugs in the workplace. Under Florida law, both public and private employers with 4 or more employees can require testing for drug or alcohol abuse. Job applicants can be tested, as can employees reasonably suspected of drug or alcohol abuse. Employers can also test employees as part of a routine fitness for duty medical examination or as a follow-up after employees complete an employee assistance program for drug-related problems. All testing must be done according to procedures set by the Florida legislature, and the results are strictly confidential. Prior to any test, the employer must give job applicants and employees written notice explaining their testing policy. If an employee or job applicant tests positive for drugs or alcohol, the employer can fire or refuse to hire the person. Moreover, testing positive jeopardizes an employee's right to workers' compensation benefits. Workplace safety and health standards. Workplace safety and health standards are governed by the Florida Occupational Safety and Health Act, Florida's Workers' Compensation Act, and Florida Common Law. Generally, employers have a duty to provide a reasonably safe work environment, including conditions and methods of sanitation and hygiene. Employees have a duty to take responsible care while on the job and follow safety procedures. All places of employment are subject to inspection for compliance with the applicable safety and health standards. Fines and criminal penalties can be assessed for noncompliance. Smoking in the workplace. The Florida Clean Air Act makes it unlawful to smoke in a public place, except in designated smoking areas. Places of employment are included in the definition of a public place, as are government buildings, courthouses, mass transit vehicles and stations, libraries, museums, theaters, grocery stores, and restaurants seating more than 50 people. Areas designated for smoking must be clearly marked, and no more than half the floor space of an enclosed indoor area can be designated for smoking. All employees working in a designated smoking area must agree with the designation. If a single worker objects, an area cannot become a designated smoking area. Please click on the boxes provided for you to the left to learn more about your rights as a worker. Employment of migrant labor. Because of abuses in the past, both the federal and state government have put in place laws aimed at protecting migrant or seasonal farm laborers. Farm labor contractors, anyone who hires, transports, recruits, or supervises farm workers, are required to register annual with both federal and state authorities. The law mandates that farm labor contractors must show their registration certification when hiring anyone for farm labor, must distribute or pay all money entrusted to them, must provide workers a written statement itemizing all deductions from wages, must prominently display at the work site a written statement in English and Spanish showing the rate of compensation he or she receives from the grower and the rate of compensation he or she is paying the worker, and other requirements. Violation of either state or federal law are punishable by fines of up to $1,000 per violation and a year in prison. Knowingly recruiting or hiring illegal aliens is punishable by a fine of up to $10,000 and 3 years in prison. Whistleblower protection. Whistleblower is the term used to describe employees or other workers who report criminal or civil violations committed by employers. Generally, Employers are prohibited from retaliating in any way against an employee, applicant, or other person disclosing information about an employer's wrongdoing. The procedure for dealing with the employer retaliation differs between the public and private sector. State employees must bring their complaint to either the Executive Office of the Governor, the Attorney General, or the Office of Public Counsel. Local government employees will have to follow whatever procedure the local government has adopted by ordinance. Private employees can sue their employer directly. The available forms of relief include an injunction against further retaliation, reinstatement lost wage compensation, or any other compensatory damages. Parental, family, and medical leave. Under Florida law, private employers are not required to provide leave of any kind. The legislature concluded that these matters are best determined by the employer/employee contract. The Federal Family and Medical Leave Act, FMLA, however, allows qualified employees to take up to 12 weeks of unpaid leave to attend to family or medical matters, including birth or adoption of a child, care of immediate family member, or care for the employee's own health. Both men and women are covered under the FMLA, thus a father can take paternity leave. FMLA. To qualify under the FMLA, a worker must be a full-time employee of a company with at least 50 employees and have worked for the company for no less than 12 months. In addition, the employee must have worked at the company for at least 1,250 hours during the preceding 12 months. During an unpaid leave, an employer must maintain an employee's health benefits at the same level as prior to the leave. When the employee returns from a leave, the employee is entitled to the same position he or she held earlier. If the same position is not available, the employee must be placed in an equivalent position with equivalent compensation, benefits, duties, and responsibilities. An employee's right to privacy at the workplace is a hotly debated issue today, as increasing numbers of employers turn to searches, surveillance, and eavesdropping to better monitor employee activities. Some employers use hidden cameras, unannounced searches, even wiretaps to keep tabs on the employees. This area of law is still largely unsettled, but it is fair to say that an employee does surrender some of his or her rights to privacy upon entering the workplace. The number of employees challenging employer practices, however, is growing, and as their case moves through the courts, a clearer picture will develop of what privacy rights an employee can expect at the workplace. Please click on the tabs provided for you on the left to continue learning about your rights as a worker. Veterans' reemployment rights. Certain veterans returning from active duty are entitled to be reemployed by their previous employers under the Veterans Reemployment Rights Act. To qualify, a veteran must have done all of the following: held an other than temporary, non-necessarily permanent civilian job, left the civilian job for the purpose of going on active duty, not remained on active duty longer than 4 years unless the period beyond 4 years was at the request and for the convenience of the federal government, been discharged or released from active duty under honorable conditions, applied for reemployment with his or her previous employer within 90 days of separation from active duty. Reinstatement must occur within a reasonable period of time to a position of similar status, responsibility, and pay. In addition, the veteran's seniority level must be at the level it would have been had the veteran kept the position continuously during military service. Unemployment compensation. Unemployment compensation in Florida is an employer-funded program entitling eligible employees to benefit in the event that they become unemployed through no fault of their own. To be eligible for benefits, an employee must be totally or partially unemployed, register for work and file a claim at the Jobs and Benefits Office, have sufficient employment and wages, as defined by the Division of Unemployment Compensation, be able and available for work. Employment rights for contractors. Independent contractors and some types of employees are specifically exempt from receiving unemployment benefits. These employees include elected officials, judges, children under 18 performing work for a parent, enrolled students working for a school or university, and employees of foreign governments. Misconduct. Persons are not eligible for benefits if they are fired for misconduct, strike, are laid off, refuse acceptable work, fail to seek new work, or quit without good cause. Good cause has been defined by the courts as meaning any event that would compel the average reasonable person to leave his or her job. This would probably include leaving due to harassment or an employer's breach of employment contract. Leaving because you simply do not like the work or the employer, however, is not good cause. Persons forced to leave because of a personal illness or disability are entitled to benefits.
What's the difference between an employee and a contractor?
Employees have more rights and are protected by federal and state law, entitled to workers' compensation and unemployment benefits, and are considered agents of the company for liability purposes. Independent contractors, on the other hand, are singular entities not covered by state and federal employment law. Employers are typically not liable for their actions.
During orientation, employment at will was briefly mentioned. What are they talking about?
Under Florida law, employment contracts which do not specify a definite term of employment are terminable at will. This means that an employee can quit or be fired at any time for any reason except those specifically prohibited by law. If your employment contract specifies a definite term of employment, quitting or being fired before this term is up can result in a breach of contract lawsuit.
That's kind of scary. What else can cause a lawsuit?
Companies seeking to defend their competitive position in the market may sue to prevent a former employee from divulging company trade secrets, or may ask an employee to sign a non-compete agreement.
What are trade secrets, and what is a non-compete agreement?
A trade secret is any information, machine, pattern, or process which may give a user an advantage over its competitors. Under Florida law, a non-compete agreement limits an independent contractor's or employee's right to compete with an employer in a specific area for a specific amount of time. Usually, this is reserved for highly valuable employees with unique skills.
Are there any rights about pay?
Yes. As of 2013, Florida's minimum wage is $7.79 per hour. In addition, any work in excess of the standard 40 full-time hours must be paid at a rate of at least 1.5 times the regular hourly rate.
Does the law provide protection against discrimination or harassment?
Yes, multiple laws protect employees in a variety of circumstances such as age for those over 40, sexual harassment or misconduct, disabilities, and pregnancy.
What counts as sexual harassment?
Unwanted propositions, demands for sexual favors, display of graphic materials, and inappropriate physical contact are some examples of sexual harassment. If you're not sure what is considered appropriate, ask your personnel office or job coach.
I have a friend who was fired when the employer discovered he was HIV positive. Is that considered discrimination?
In most cases, yes. Individuals with AIDS or HIV are protected by both state and federal law. However, in some cases, the absence of HIV may be a qualification for the job, as is common in the healthcare industry. When it is not a bona fide qualification, employers cannot require an individual to take an HIV test as a condition of hiring, promotion, or continued employment, terminate or refuse to hire based on HIV status, and segregate or classify employees with HIV or AIDS. You should tell your friend to speak to an attorney because Florida law prescribes certain damages in the case of unlawful discrimination based on HIV status.
So discrimination is always illegal?
Not exactly. There are some very limited situations where there are qualifications based on age, sex, religion, language fluency, and physical or mental ability. For example, a religious organization may legally refuse to hire a qualified candidate who does not share their beliefs, and a man can be denied a position as a woman's locker room attendant.
Am I protected from unsafe working conditions?
Employers have a duty to provide a reasonably safe work environment, including methods of sanitation and hygiene. You, as an employee, also have a duty to exercise reasonable care while on the job and follow all applicable safety procedures. These standards are governed by the Federal Occupational Safety and Health Act, Florida Workers' Compensation Act, and Florida Common Law. Violations may result in fines and criminal penalties.
They said I can't smoke at work. Isn't that discrimination?
Sorry, Sam. Not only do employers have the right to forbid the use of any tobacco products on premises, smoking indoors is prohibited by state law. Even if you are given a designated smoking area, all employees must agree on the location.
If I think my employer is doing something against the law and I tell law enforcement, can they fire me?
Generally, employers are prohibited from retaliating in any way against an employee who reports civil or criminal violations committed by employers. This is called whistleblower protection. If you feel this has occurred, contact the Executive Office of the Governor, the Attorney General, or the Office of Public Counsel.
What other rights should I be aware of?
You should be aware of the Family and Medical Leave Act if you are considered a full-time worker, which entitles an employee to take up to 12 weeks of unpaid leave to attend to family or medical matters. You must be employed for at least a year and have worked at least 1,250 hours during the last 12 months. You can return to your original position or an equivalent position if your original position needed to be filled while you were out.
If someone is called to active duty, is this considered FMLA?
No, this would be a right to employees under the Veterans Reemployment Act. This means that certain veterans returning from active duty can return to their previous employment if the job was not considered temporary, if they have not been on active duty longer than 4 years, if they have been discharged honorably, and if they applied for reemployment with the previous employer within 90 days of separation of active duty.
That is a lot to remember.
I know, Sam. You do not need to memorize the details of all rights you are entitled to if it is too much for you. Just remember you have many rights as a worker, and if you feel uncomfortable and it's possible one of your rights have been violated, contact someone in your circle of supports to assist you with determining if there was wrongdoing.
Dealing with stress and anxiety on the job. Stress, or the bodily reactions and responses to threatening or difficult situations, is a natural fight or flight instinct that is embedded within all individuals. Manageable levels of stress for a reasonable duration enables an individual to be creative and efficient at work. However, when stress becomes too much, the body reacts in an extremely negative manner, causing disruptions to normal functioning and can contribute to the development of numerous disorders and diseases. Occupational stress. As humans, most of our time in life is spent working compared to any other activity. Occupational stress is a result of a factor or combination of factors at work. It interacts with the worker to disrupt their psychological or physical well-being. It can be caused by a number of factors, including work simultaneous overload, resulting from a perception of excess in terms of what the worker is expected to do. It may also be the ambiguity of the task required of the worker. Work simultaneous underload occurs when there are not enough tasks for the worker to undertake. Lower performance due to stress. Causes absenteeism, reduces the quality of work, causes mood swings, reduces ability to make decisions, causes hostility towards other workers, causes overreaction to mild work pressure, causes a shirking of responsibilities. Consequences of stress. Diseases. Stress has been the consequence for 50 to 80% of diseases. Insomnia. The inability to fall asleep. Hypertension. High blood pressure, which would lead to lethal complications. Aging. Research has proven that people age faster when they experience more stress. Symptoms of stress. Stress is the tension caused by situations. It is estimated that 80% to 90% of all illnesses are related to stress. Work-related stress could be caused by such things as too little time to accomplish a task, poor instructions, a lack of organization, etc. Stress can be self-induced or induced by others. What is important is to recognize stress and to find ways to reduce it. The following are some immediate signs of stress: tense muscles, increased perspiration, rapid pulse, tight stomach, nausea, chills, pounding heart, flush of the face, lightheadedness, shortness of breath, reduced ability to concentrate. Long-term disorders due to stress: diabetes, ulcers, asthma, heart disease, high blood pressure, bronchitis, arthritis, kidney disease, death. More symptoms of stress: sleeping problems, fatigue, indigestion, headaches, loss of appetite, diarrhea, muscle pains, hives, or rashes. Psychological disorders caused by stress: nightmares, loss of memory, anxiety, nervousness, depression, loss of motivation, anger, paranoia. Tips of stress management: 1. Get strength from your spiritual beliefs. 2. Create a network of friends. 3. Involve yourself in social activities. 4. Do something fun at least twice a week. 5. Manage your time effectively. 6. Reduce your consumption of coffee. 7. Make some quiet time during the day. 8. Be a positive thinker. 9. Stand up for yourself. 10. Take time to relax and breathe deeply in stressful situations. 11. Picture yourself in a wonderful setting while closing your eyes. 12. Ask yourself, will it matter in a year from now? 13. If a person needs extra support, talking to a mental health, occupational stress, or psychological specialist or a professional counselor may help. Some workplaces also have an employee assistant program or counselor, which are useful sources of support. Tips of stress management: 1. Eat at least one hot, balanced meal a day. 2. Get 7 to 8 hours of sleep per night. 3. Give and receive affection regularly. 4. Have a family member or friend that you can talk to. 5. Exercise at least twice a week. 6. Eliminate tobacco products from your lifestyle. 7. Eliminate alcohol from your lifestyle. 8. Don't live beyond your means. Please click on the tabs provided for you on the left to learn more about dealing with stress and anxiety on the job. Coping with change. Change is a part of everyday life. It can be big, small, subtle, or sudden. It can be positive if you choose to see it that way, or just plain difficult. In the workplace, change is occurring at a faster rate than ever. Technology is moving forward at an incredible rate, and the result is a constant need to update skills and knowledge and to make frequent changes in how we do our jobs. Change can make people feel stress, sadness, anger, worry, or anxiety. When there are changes in the workplace, learning to adjust and work with new arrangements can be difficult. Make change easier. Some tips for making the change easier are: maintaining a positive outlook, talking to somebody, remembering the things that haven't changed, being prepared to feel some stress. Fear and anxiety. Everyone at times experiences anxiety and fear. They are normal human emotions that help us deal with danger. However, some people experience excessive and irrational anxiety and worries that become ongoing and distressing and interfere with their daily lives. This may indicate an anxiety disorder. Often there appears to be no obvious or logical reason for the way the person feels, which may make an anxiety disorder even more worrying to the sufferer. Activities to reduce stress and anxiety. If you have feelings of anxiety, it can often be very calming to talk to a friend, relative, or counselor so these feelings don't end up getting beyond your control. Look after your mind as well as your body by adopting a healthier lifestyle, including regular exercise, a healthy eating plan, regular sleeping patterns, and learn to reduce stress levels by relaxing. This is different for everybody, but some suggestions include watching TV, reading a book, going for a walk, going to a movie, or having a long bubble bath. Jeff, I've been working at my new job for about 3 months now, and I am becoming very stressed out. I need some help before I lose my job. I just don't know how much more I can take.
I know a little about stress management. I think I can share a few tips that might be helpful for you.
That would be great.
First, you should understand what stress is, and then you can learn how to manage it. Stress is your body's reaction to threatening or difficult situations. Manageable levels of stress enable you to become more efficient and creative at work. However, when stress becomes too much, the body reacts in an extremely negative manner. This is probably why you are just now becoming overwhelmed after 3 months of employment.
I never felt like this until I became employed. Why now?
This is called occupational stress. There are different causes of occupational stress. It can be due to work overload, where you feel like you are expected to do more than you are capable of. You could also experience occupational stress due to work underload. This is due to not having enough tasks to complete.
What will happen to me if I don't manage my stress?
Well, as you mentioned, you may ultimately lose your job. This is because stress can cause absenteeism, reduced quality of work, mood swings, inability to make decisions, hostility towards others, and overreaction to mild work pressures.
I heard stress can kill you. Is that really true?
It is estimated that 80% to 90% of illnesses are stress-related. Stress can cause a variety of diseases: insomnia, hypertension, and aging. What is most important is to recognize signs of stress and find ways to reduce it. Some immediate signs of stress are tensed muscles, increased perspiration, rapid pulse, tight stomach, nausea, chills, pounding heart, flushing of the face, lightheadedness, shortness of breath, and reduced ability to concentrate.
I feel a lot of those signs all the time. Won't they just go away eventually?
Yes, they will go away, but can eventually cause diabetes, ulcers, asthma, heart disease, high blood pressure, bronchitis, arthritis, kidney disease, and eventually death.
Wow. I should really make sure I manage my stress, huh?
It is definitely more serious than some people consider and should not go unmanaged.
Are there any other signs I should be aware of?
Sometimes people under stress experience nightmares, loss of memory, anxiety, nervousness, depression, loss of motivation, anger, and paranoia as well.
Okay, so now that I'm aware of the signs of stress, how do I manage all of these signs?
There are several ways you can manage stress depending on what works best for you, but here are a few tips you can follow. Eat at least one hot, balanced meal a day. Get 7 to 8 hours of sleep each night. Make sure there is someone available you can talk to. Exercise regularly. Eliminate tobacco and alcohol. Involve yourself in social activities. Think positive and try to relax and breathe deeply when you feel signs of stress.
Great! I'm going to try a few of these tips and see what works for me. Thank you so much for your help, Jeff. Handling mistakes made on the job. Nobody's perfect. You might be close, but let's be real here. Mistakes are going to happen. It's a fact. You will need to deal with the consequences one way or another. That's also a fact. Just remember that the way in which you deal with a mistake may have a widespread ramification on your possible future with a company. Your mom was right. Honesty really is the best policy. Handling mistakes on the job. It happens to all of us sooner or later. Somewhere along the line, you're going to make a mistake on the job. This might be disconnecting the company's most prominent client while on the phone, authorizing an incorrect shipment of merchandise, or maybe simply spelling your president's name incorrectly on a letter you typed. Whatever the case may be, you need to decide how you're going to handle it. First off, the mistakes may be brought to your attention in a number of different ways. Perhaps your immediate supervisor will come to you with the news, or you may hear about it from an out-of-company contact, or you might catch it yourself. It all depends on the mistake that has been made. Handling mistakes with a level of professionalism. In all cases, however, the way you handle the matter can tell a lot about your level of professionalism and job loyalty. You might try to evade the issue. Perhaps you'll tell your supervisor that the task was not properly explained in the first place. Chances are these methods, whether true or not, will not be the most constructive. Even if the task was not properly explained, you have the responsibility to ask key questions before, during, and upon completion of the task, if need be. Putting the blame on your supervisor will not cast you in a very good light. Don't blame someone else. Another tactic is to blame someone else. Perhaps the task required a number of people to complete. Surely one of these people should have caught the mistake before completion. Again, by placing the blame on others, you send a certain message to your supervisor. You are not willing to take responsibility for your actions. Admitting your fault. How about admitting your fault? Surely this isn't the answer. Oh, but it is. Managers are concerned with mistakes. Even more so, however, they are concerned with ensuring that mistakes are not repeated. By admitting your fault, you are saying that you are willing to take responsibility and you are willing to work on the methods to make sure the mistake is never duplicated. Express your feelings. What about mentioning how you feel about the mistake? Again, this is not a bad idea. Letting your supervisor know that you feel terrible about making the mistake in the first place will most likely help them see that you realize the significance of your error and that you will be more careful in the future. Hey Beth, how are you?
I'm okay, I guess.
Is there something you want to talk about?
I'm just worried I may lose my job.
Why is that?
I just keep making silly mistakes, and I feel like my boss is going to fire me.
It happens to all of us sooner or later, Beth. Somewhere along the line, you are going to make a mistake on the job. You may find out you made a mistake on your own, or your boss may bring it to your attention. But however you find out, what is most important is how you handle the matter and your level of professionalism.
Most of the time, I feel like there are simple mistakes that can be avoided, but sometimes they aren't my fault.
It is very important that you take responsibility for a mistake that was made on your behalf, even if the task was explained to you incorrectly or may not have been your fault. By placing the blame on others, you send a certain message to your supervisor that you are not willing to take responsibility for your actions. The best thing you could do is admit the mistake was your fault and work on methods to improve.
Should I apologize to my employer?
This is not a bad idea, Beth. Letting your boss know how terrible you feel about making a mistake will show your loyalty to the job. No one is perfect. Everybody will make a mistake at some point. Just remember, the way you deal with your mistake may have widespread ramifications on your possible future with the company.
Thanks, Cindy. I feel a lot better now. I'm going to talk to my boss when I go into work and apologize for my mistakes and let him know I'm going to try my best to work on improving.
You're welcome. I hope everything works out. Coping with change and other challenges. Click on the buttons below to find out more about coping with change and other challenges. Coping with change and other challenges. Adapting to change and being flexible are required skills for success in the workplace. A person who is rigid and closed to change will have a difficult time adapting and moving ahead in the workplace. Change is a process. Change is a process, not an event. It occurs over a period of time, and it requires ongoing management in order to last. Change in human behavior involves steps, each one harder than the one before. Change is a highly personal experience. Change involves developmental growth. Tips for embracing change. Be a change agent. Change yourself first. Practice continuous improvement. Practice self-motivation. Keep a positive attitude. Have the necessary skills. Manage your own morale. Coping with change and other challenges. A very important part of responsibility is making and keeping commitments. It is impossible to be taken seriously if you don't keep and honor your commitments. Commitment is a serious promise to press on, to get up no matter how many times challenges and life may knock us down. Being responsible and demonstrating commitment is not easy, just like the road to success. It's easy to get discouraged sometimes. It's easy to think the road is too hard, or it's taking too much time, or just not worth all the effort. Commitment is well worth the price in the long run. Not only will your relationships improve in all areas of your life, but people will notice that you have what it takes to succeed. If you are true to your values and committed to success, people will be drawn to you.
Scott, I think I just might quit my job. They are constantly changing policies and procedures, and I don't know what I'm supposed to be doing half the time.
Hey, adapting to change and being flexible are required skills for success in the workplace. I don't think you should quit your job. Change requires ongoing management, which is a highly personal experience and involves developmental growth. I think there are ways you can cope with these changes so you can keep your job.
Like what?
Practice continuous improvement, practice self-motivation, keep a positive attitude, and manage your own morale. Showing commitment to the company means dealing with changes and unexpected events. It's easy to quit, but committing to the company during changes shows you have what it takes and your ability to succeed.
Maybe I'll stick it out with them and see if it gets better.
The company is probably going through a major transition and needs loyal employees. I think it is a good idea to stick around and try your best to cope with these changes.
Thanks, Scott.
Giving and responding to feedback. Please click on the tabs above to continue to learn about handling feedbacks. Tips on giving feedback. Describe the person's behavior which bothers you. It bothers me when you finish my sentences for me. Talk to the person right when things come up. Don't wait until things are likely to have been forgotten. Use I messages. Own your feelings. I feel bad when you finish my sentences for me. Check for clarity. Do you understand what I mean when I say that? Give consequences if behavior continues. If you keep interrupting me, I most likely won't want to spend time talking with you in the future. Only bring up behaviors that the person can do something about. Be ready to listen to the other person's point of view. Don'ts. Don't accuse the person. You always interrupt me. Don't bring in third parties. John also says that you interrupt a lot. Don't take for granted that person understands what you are saying. Don't give vague consequences. That kind of behavior is going to get you in trouble. Don't bring up behaviors that the person can't help. The way you breathe really bothers me. Don't deny the other person's feelings. Tips on receiving feedback. Listen to the feedback without getting defensive. Do not blindly accept what you are told as the ultimate truth. Paraphrase the feedback to make sure that you understand correctly what is being said to you. Remember that all feedback is helpful because it gives you a chance to see how others view your work. Follow through on the areas of improvement that are discussed.
Sometimes I have a hard time giving and receiving feedback. I don't take criticism well, and I don't want to offend other people by criticizing them. Can you help me with that, Michelle?
Sure. There are several things you should pay attention to when giving feedback. Make sure you are very specific when describing something that bothers you. Instead of saying, "It bothers me when you don't let me speak," say, "It bothers me when you finish my sentences." Don't wait to express feelings either because emotions rise the longer you wait.
What if I keep telling someone they are bothering me and they don't listen?
Make sure they understand you. Ask them if they understand what you are telling them. Make sure you are only bringing up behaviors that the person can do something about. This may be why they continue to do the same thing. It's not that they aren't listening. They probably can't change it.
What should I avoid?
You should avoid accusing the person. Avoid mentioning other names. Don't give vague statements. Don't bring up things that the person cannot change. And avoid denial of other person's feelings.
What should I do if someone is giving me feedback?
Good question. Make sure you are listening without getting defensive. Paraphrase the feedback to make sure you understand what the other person is asking. Remember that all feedback is helpful because it gives you a chance to see how others view your work. Make sure you follow through on the areas of improvement that are discussed.
Thanks, Michelle. I feel like communication is very important and there's always room for growth. I just wanted to make sure I'm doing it the right way.
No problem, Demita. I like that you are such a positive and proactive person.
Thanks.
Conclusion. Now you have learned that reasonable accommodations are defined as including getting and understanding of scheduling, benefits, deductions, and how to manage your paycheck. You have also mastered what your rights as a worker are, as well as how to handle stress and anxiety on the job, handling mistakes on the job, coping with change. Also, how to effectively respond to feedback, dating at work, standard policies, and procedures.